illegally speaking, with me, Tarun Nangia. Social media thinks that every remark that a judge makes is a judgment. This is what Justice Chandrachud said, and not in a lighter way. He meant that, we've seen on and off that a judge makes a statement in court, and there is a barrage of criticism on social media without understanding the context in which he's spoken something. Many times judges speak or interact to arrive at a certain conclusion, to derive certain answers, but nothing is paid heed to. One statement is taken, and then you see that armies of trolls descend on social media, and the nastiest of the things are said. This is something we should all be worried about. And Justice Chandrachud is one of the most liberal of our judges. We've seen how he's welcomed everything from digital courts to online, in a sense, video streaming of proceedings. He's welcoming all of this. But when he says something like this, we all should be concerned. And that's why we discuss this issue today. Let me welcome Ryan Karanjawala, Managing Partner of Karanjawala and Company, one of India's leading litigation law firms. Senior Advocate Parag Tripathi joins us, top counsel of the Supreme Court of India. Good to see you, Mr. Tripathi. And waiting for some shairi from your end, which is in tune with our topic today. I have with me Mohit Saraf, Managing Partner of Saraf and Partners, one of India's leading law firms in the M&A and the litigation space. I have with me Percy Bilimoria, Senior Advocate practicing at the Supreme Court of India and the Delhi High Court. Good to see you, Mr. Bilimoria. And at the outset, let me start with one anecdote that, in a sense, when you talk of liberty, we've seen that our judiciary and judges, especially Justice Chandrachud, they have been encouraging this in various of their statements that they make from time to time. Even Justice Ramanna made statements regarding the press that they should be encouraged. But when these kind of messages come from the bench, then we should also introspect where we are going wrong. And that's why this show today. I'll go to Mr. Karanjawala.
Phone will be given. Sorry.
I'll go to Mr. Karanjawala for the opening comment, and then we begin the show. Over to you, Mr. Karanjawala.
So this is the problem that an old system faces when it's dealing with a new medium. Over the years, ever since we joined the bar, people have been arguing in court. Judges have been expressing their views to counsel, putting a counterpoint across. The counsel in turn has been rebutting the same. But all of this has gone in the close confines of the court. Then, as time progressed, newspaper reporters started reporting what was stated in court. But obviously, these are people who are seasoned reporters, people who have seen long arguments over the years. And therefore, what you get is a seasoned reporting and accurate reporting of what the judge really said in court, with the contextual understanding that this is not the judge's ultimate viewpoint. This is just something that he said in the normal up and down of argument between counsel and court. Now what you're doing is, and this is in fact an important triggering point for another debate on your show, Tarun, which is that are we really ready for a system where we have live streaming insofar as courtrooms are concerned? Because now what you're seeing is that suddenly, especially because of COVID and especially because these things came through the, because they were on online, and especially because hearings had become online, a large number of people started listening in on different arguments, different debates. And then what started happening is, as matters also are more heightened, as matters also are more volatile, everything that the judge says is taken, sometimes twisted out of context, and then hammered on the social media. It's something which is obviously very unfair to the judges because they have no way of protecting themselves. Once something is stated about them, it goes viral. Next day, clarifications can come forward, but nevertheless, it will be all lost in the din. So this is a very important issue. I'm glad Justice Chandrachud spoke out about the same. And in fact, earlier, Justice Pardiwala also had occasion to mention how comments made by judges get taken out of turn, get trolled, get spoken about adversely in the public domain, and then the judge is at a disadvantage. Now, if these things are allowed to continue, then the judge will start finding that he has to sort of second guess everything he says before he puts it across to counsel. And the debate between counsel and the court will not be a healthy one. It will start becoming very wary. People will be very wary about what they want to say. So this is something that we have to slowly take into our consciousness and see as to how best we can deal with such a situation.
Thank you. Thank you for that opening comment. I'll go to Senior Advocate Parag Tripathi. Now, Mr. Tripathi, we're talking of one of our most liberal judges. Justice Chandrachud has been pro-digital hearings, pro-live streaming of proceedings. And, there is every country has a certain way. India has a certain way. The collegiate system is unique to India. Many things are very unique to this country. The society, the social construct, how we discourse on social media, it is different in United States, different in India. Keeping the Indian context in mind, can you give me an opening comment?
Yeah, Tarun, this is a very important issue, and it's not just an issue of judges and the impact this kind of trolling or potential trolling can have on their ability to act according to what they think is right. It is also raising a broader issue of functionality of rule of law, because it really impacts on the judicial system to deliver justice really. Because if I'm going to argue a matter and I'm going to worry how will I be trolled in the evening, then I'll have to modulate my arguments. If that can happen to a lawyer, surely it can happen to a judge.
Yes.
Now, this aspect came up actually for judicial examination in a judgment incidentally written by Justice Chandrachud himself. That is from the Madras High Court, the Election Commission matter, where certain comments were made by the division bench of the Madras High Court, and the Election Commission had come and said that please expunge all those comments which don't find a part in the judicial order. And naturally, the court said that a comment which doesn't find a place in the judicial order is not there in the judicial record. And there, I think the court then laid down the 3 or 4 very important principles of open courts and Indian judiciary, freedom of expression in the media, public discourse, and freedom and constraints on judicial conduct. But the point we have to remember is this, as Ryan himself said, the internet space is something which is very new of the last 2 decades. There are 2 defining features of internet space, which are very, very different from the defining features of an open court and rule of law. And these 2 defining features are inclusivity. Anybody can get up anytime and write or say anything. You can't do that in a court of law. Even if you are a lawyer before a judge, I can't speak out of turn. If I'm not even a party before the court, then there's no question of my raising my voice from the gallery and saying, sir, I think you're wrong. So there is inclusivity in internet space of a kind which is impermissible, and rightly so, in a court of law. Secondly, internet space is of unconstrained dialogue. You can say pretty much what you want. That is not how you function in a court of law. And we have to remember that when a judge asks a question or says something, then a judge is really many times doing devil's advocacy to test a point. Right. Understand what is it that Mr. Karanjawala is arguing, or what is it that Percy or Mohit is arguing, and then say, but all right, I'm putting it to you. And then he'll put a question which may be troubling him because he's looking at his judgment. Remember, a judge speaks through his judgment. He of course speaks in a courtroom, but that is not the judicial speech. The judicial speech is what he speaks from the judgment. At this stage, out of my great deference for my good friend Tarun, may I remind you of a very nice couplet of Akbar Allahabadi, who was incidentally a district and sessions judge of Allahabad. And he said, and this may be true, actually this may represent a bit the views or the feelings of judges who have been wronged on the social media, which is, हम आह भी भरते हैं तो हो जाते हैं बदनाम, वो कत्ल भी करते हैं तो चर्चा नहीं होती.
Wow.
Thank you for that interesting opening comment and the share. And I'll go to Mohit Saraf for his opening comment. Over to you, Mr. Saraf.
I think, Tarun, I think what Ryan said and Parag said, I think it's pretty much on the topic. I think particularly what we're talking about freedom of reporting in the new age, where when you are reporting each word of it, obviously the context gets lost. And obviously the most important line or most, I would say, and a line which draws a lot of attention and a lot of viewership gets overly empowered or get top feature, and therefore it's always out of the context. That's one aspect of it. The other aspect of it is, do we need to regulate? Because I think particularly the type of people who are writing it, and sometimes it will be out of context. That is one part of it. Do we need to regulate, and how well we regulate? Because really, most people are reporting, but their reporting is obviously always out of context, because even in any dispute, if you're reporting every line which is being said, any line can be out of context. So that is one part of it. The second part is that probably the country wants to know and what is going on in mind of the judge. And therefore, there should be some level of freedom. The problem is that this freedom compromises, as was Parag said, the rule of law, because judge would, because of the amount of internet and Twitter and things like that, he may be drawn toward thinking what will happen, how the media will react, how will people react. And you've seen how courts have reacted and the media has reacted to various stories about whether it's a Nupur Sharma or whether it's about the farm law. So I would say there are a lot of issues, and this is a very important debate. I think this compromises independence of judiciary. It lowers the dignity of the court. But on the other hand, you don't need to over-regulate, because then the freedom is lost and people do not know what the judges is. And again, I don't know how can we find a balance? And that will be a big challenging, because really none of us wants the rule of law to be compromised.
Thanks for that opening comment. I'll go to Mr. Percival Bilumoria, senior advocate, but I have an interesting story to tell. Mr. Bilumoria brought this issue to my notice 2 days ago. And when we first discussed it about Justice Chandrachud, and then when I invited him for the show, he actually unfortunately fell ill. I think he has a cough, a fever or something. And then when I invited him, he said, no, I'll make it. So finally he's made it. Over to you, Mr. Bilumoria. I know you're not in the best of health as we now discuss this than you were when you first showed me the idea, but nevertheless, your opening comment on the show.
Right. So I think a couple of points that have been already discussed are very critical. One is, as a lawyer arguing in court, you actually like the judge to be interactive. Yeah. Because it shows what the justices are thinking and it allows you to address that. So this is very important. But another point that I think Justice Chandrachud made, which should not be lost, is that this is not reflective of opinion. That's the whole thing. Something may be said, which is more to interrogate the lawyer or to say that this is the doubt in my mind, please show me what you're saying, or where is it on record. That does not constitute the view of the judge at that particular point of time. The view of the judge is what comes in the order of the judgment. This is the whole issue. And I don't think our society understands this, and social media, of course, not. Look, when this concept of citizen journalists came in about a couple of decades ago, I remember there were a lot of scholarly editorials that came out bemoaning the fact that now the era of the editor's pen is over, because you will have all kinds of unverified reports creating a lot of panic, and sometimes this can get very dangerous. In most cases, it doesn't really have any impact. It's just the opinion of a few people, but on certain occasions, it can get very dangerous.
Okay, thanks for that opening comment. I'll go to Mr. Karanjawala. I remember discussing with you when Justice Pardiwala had made a comment and he was very angry at being trolled on social media. But he put it out very bluntly. And now we see Justice Chandrachud also has spoken in different words, but in a similar tone. Do you see a pattern in here that judges are also finding out that this is deployed criticism, or suddenly armies of people take up one issue, one statement, and start creating a certain environment which then engulfs the whole social media? Do you think this is akin to an organized racket trying to pressurize judges?
So I won't go so far, but what happens very often is, first of all, Tarun, it depends entirely on the kind of matter you're hearing. if you're hearing a matter A versus B, which is where only A versus B are interested, then nobody is really going to spend much attention or time or really troll you. But if you take up, which the court has to, and the court today does, especially the Supreme Court, sensitive matters, matters in which a lot of people are interested, matters in which the tempers are already high, matters in which things can get agitational, then naturally, any comment that you make will, insofar as a large section of people are concerned, suddenly get a counter viewpoint or get a pro viewpoint, and then you're sort of almost in a sort of a political slugfest. You find yourself at the receiving end of a lot of unnecessary trolling. One way to tackle this is, in the old days, what used to happen when matters were heard in court, every paper had an accredited journalist who was, specific to the courts, who was familiar with the courts, and he would come forward and say that, well, this is what happened in court, this is what the judge said, this is what the lawyer did. Now, in the internet era, when people can access the court through the internet medium, one way to do it is perhaps the court can seriously consider that, look, let us take 4 or 5 portals, say Bar and Bench, Live Law, other things, and we give them an accreditation. And they, in turn, therefore, are obliged to report in an orderly way what actually transpired in court, so that people then, in the large populace of people, if they want to see what actually happened, they go to those scheduled, accredited sites and read what happened, and there they will find a balanced viewpoint put forward. Something like that needs to be explored. Just as in the old days, you had an accreditation of a reporter who could come into court. Today, maybe 5, 7, 10, 15, it depends on how many there are and how many are credible. People can get accreditation. The Supreme Court registrar can say, well, look, we hold that these people normally put out things in a very responsible and constructive way. Secondly, the advantage is that if you're dealing with 4, 5, 10, 15 portals, if you find that 1 or 2 of them is saying something which you think was slightly wrong, the registrar can immediately call, and since this is all online, it can get corrected in a few minutes. So this is one way of having a repository of what is accurate reporting in one particular place. And that might well help in the ongoing situation and the ongoing debate. Because otherwise, in the internet era, the judges and the lawyers are going to find themselves living what they call a goldfish bowl existence, where all the time they are under constant scrutiny and there's not much they can do about it. So this is something, this is an ongoing debate. This is something that will have to be thought out, especially in the era of streaming video, live videos. In fact, if I can take a minute, I just digress on something which is important to counsel, more important to counsel than it is to the judges. I noticed one thing which happened during COVID. During COVID, as you remember, everyone was arguing online. Now, in the old days, what used to happen is a counsel would go in, make his point, hammer away, that the client would be sitting 20 feet back. He got a broad idea of what the counsel said, and he would go home. And the solicitor would say, no, our boy argued very well. We made all the relevant points, and everyone went home happy. Now I started finding during COVID that they would come back to us, because what used to then happen is quietly, the client would, even though he was not supposed to, quietly tape record everything. Then go back home and sit at leisure for 2-3 hours and go again and again over every point that the counsel had made, and then come back to you and say, "But sir, ye to nahi bola wo." Nahi bola? Nahi sir, nahi, humne to nahi suna nahi. And I started warning our counsels, be a little careful, because now everything you say is under so much more scrutiny. Even conferences that you have with clients, which are not court proceedings, people would say, but he said this, but then why did he say this? And when clients have the advantage of hindsight and repeated viewing of the same thing, obviously they're going to be much sharper at detecting any flaw than they were otherwise. So this is a new era which everybody will have some difficulty getting used to.
But I'm taking forward what Mr. Karanjawala said. Mr. Tripathi, you have the benefit of now arguing in courts for decades. And that is why I want to ask you 2 things. Every democracy matures differently. In India, we outrage on trivial issues and sometimes it is also in the national press. The most trivial of the issues can make it to the national press and 9 p.m. debates. And this is an everyday phenomenon. On social media also, comments are taken out of context, which may not happen in other democracies, say like America or UK. Would you take that argument forward? Do you think we need to mature as a democracy? Otherwise, say with live streaming and other things, would we be able to appreciate these things in the right context as a society? Appreciating the independence and the access we get to information rather than criticizing it from an organized standpoint. Or, some people mobilize the entire criticism that, if you want to target somebody, just take out 2-3 comments and start hammering him day in and day out on social media.
Tarun, you raise a very important point, but it's a double-edged sword. Should you be mature enough before you get the full benefits of democracy and rule of law? Right. My view is a little different there. My view is democracy is like swimming. You pick up the bloke and throw him in the water. He'll learn. Right. So you have to learn as you go along. You can't await that I will apply full democracy later. But having said that, what you say is correct. In many ways, we jumped from feudalism to a democracy. We did not have the in-between period of churning. That is true. But coming back to, I think, yet another important aspect. You see, the problem is that social media today is really, internet space is a virtual watering hole, right? Where people just come and let go. Now, this has, in American jurisprudence, you have the concept of what they call a verbal slap or a chilling effect. So this is a huge chilling effect on the freedom to think as you will and talk as you think in a court, both for the judge and, as Ryan said, for the lawyer. There are many times a lawyer will say, yes, I quite see that point. The client, when he does an action replay and again reads, hears and sees it again, he'll say, but he didn't raise this point. Why did he do so? Because there are so many things which you have to leave to the best judgment and discretion of the lawyer and the judge's ability to ask that question without having the fear of a backlash, because there's no question of a backlash in court. And as all my friends will agree, the most difficult judge to argue before is what is called a non-speaking judge, because you have no idea what he's thinking. And if you will allow your unbridled internet space to function like this, then you are compelling your judges who are right-thinking and talking judges into becoming non-speaking judges, which will be a very sad.
That's such a beautiful point that you'll stop judges from speaking altogether. They just keep on reaching out.
I will say I want to ask Ryan this question. I will not ask him because Ryan will answer it. But what will happen to the trolling when I go back home? So that is
ultimately the losses of the litigant and the lawyering public.
Of the lawyer.
That is the real loss. Because frankly, as far as we are concerned, if we don't get the benefit of the judge's question, we are not able to answer it. And then, you will soon come down to a situation where you might just have written briefs. So you have to have a situation where there has to be a self-imposed restriction on your shooting your mouth off in the context of what the judges said.
Fair point. And
Arun, just 2 quick points. Many times what happens in even sensitive matters in court is the court will say, Mr. Tripathi, don't do these things. Don't rock the boat till the next day. I'm not putting it in the order. This happens so many times. Now, if you are going to have this put over in the internet space, that Tripathi meekly agreed to it. It's not meekly agreeing. You're just not rocking the boat the next day. Both parties have understood it. You don't want it in the order due to various reasons. Now, there is 2 more things I wanted to quickly touch. One is that, remember, there are 2 great constraints in the judicial proceedings. One, it's a winner takes all, and the loser can never be happy. Many times, as Ryan will tell you, winner is also not happy. But certainly the loser will never go out saying, I have got excellent judgment. I really, really am very happy with it. I have not come across a single time that I have lost that my client has said that. Maximum you have said is, you argued well, but they didn't understand you. That's as much as he's willing to go. So there is a problem here. So when you have a winner takes all, naturally one party will always be aggrieved from the justice which has been given, and he'll be more than willing to troll anybody whom he can set his eyes on. And secondly, a judge cannot have a private follower. A judge can't, if I'm being briefed by a solicitor, leading solicitor, I can just call him and say, boss, I've not understood this point, just tell me again. The judge can't do that. Therefore, the judge must ask you in court. Otherwise, he has to list the matter again.
Very good point.
Very, very important. Therefore, and in the end, may I just remind you of what Ahmed Faraz had said, and which is actually true, because we all love people, internet people particularly, and all of us love gossip, and we need somebody at whose expense that gossip can be generated. So he says, हम न होते तो किसी और के चर्चे होते, खलकते शहर तो कहने को फसाने मांगे. Calcutta share is people of the city. They want some story to tell. Now, problem is that story should not be of what is happening in a court of law in a wrong way, because that is destructive, as I said, of the whole judicial process.
Point well taken. I'll go to Mohit Saraf and then to Percy Bilomoria. We'll close the show after that. Mohit Saraf, quickly your comment, and then Percy Bilomoria comes in.
I think, Tarun, if you think this is happening across every sector, all of us on this show can tell you that we all compromised our work-life balance to reach where we reached. But today, if you talk about this issue anywhere, whether internally in the firm or outside, you are on the receiving end, as if you would just, anybody who talks about compromising, or because all of us have the same hours, some of us has to work harder to get there. So I would say that is really across every sector. But when it goes to judiciary, I think it has a much bigger implication. It compromises rule of law. It compromises, judges may get compromised in the sense they are thinking about what is the world, what is the media thinking about it. And we always knew that you cannot criticize the judge. You can have a constructive argument or disagreement on the judgment. But by what is being done is you basically belittling somebody, that how can you say that? And you can see what happened about the Nupur Sharma case. So all these issues, in my view, though I don't want it to be regulated, but I feel that since the impact of this is not just democracy, rule of law, and people will get very bogged down, judges will get bogged down, because really everybody gets bogged down.
In fact, because when you said bogged down, Parag also echoed something to that effect, that judges will go silent. Mr. Karanjawala said the same. I want to take this question to Mr. Bilomoria. Now, you also argued for decades in the court of law. Judges go silent this way because they feel that they'll be misinterpreted deliberately and trolled. Earlier, I remember Prime Minister Narendra Modi saying something to this effect. When he said that it is difficult to joke anymore while you give speeches, because God knows that somebody will just take up a comment and start to troll you on social media. So even, in political discourse also, politicians don't joke anymore in a lighter vein because they're taken in the other context. What would you like to say?
I think one big point that has come out of this discussion is context matters. I think that's something that we must keep in mind. The other thing is also, I must say that there is a lot of grandstanding. I'll just give you an example of what happened yesterday. So we were before the Supreme Court, and the court said, look, there's not an adequate time, and I'm giving you another date. And the briefing counsel to my left is prodding me and saying, say something. And I said, what do you want me to say? We're getting a date. He says, no, say something. So something to the effect that, look, a lot of people are getting affected, across the country. This is grandstanding. So this is also something that we as lawyers have to avoid.
Okay.
We have to be mindful of this.
Okay, point well taken. Now, I've got 30 seconds to finish. Mr. Karanjawala, you want to bring in a closing comment?
Well, actually, I've said more than my share. Why don't you give it to the others?
So I'll take this to Parag. Parag is the next.
I have this nightmare, a recurring nightmare, that with live streaming, because we are the generation after Swapnil Tripathi's judgment, which said that there should be live streaming. You will have, just as like you have in a cricket match, the judge has asked this question, what do you feel? It affects the case of the plaintiff. It adversely affects the case of the defendant. Don't know. And then in 1 hour, they'll say 32% said he's down, 36% said this man is up, and 20 said, I don't know. That will be really a black letter day. because you cannot treat judicial proceedings as if it's a cricket match and one star batsman has got out. It's a much more complex thing. It is much more dynamic, and it requires that cocoon of freedom. There has to be freedom, and there has to be a cocoon of insulation. You can't keep on reacting. You have your participation in open court is a participation of a listener, not a person who will interact with the judge. And that is something we have to train ourselves to and train the citizenry about.
Thank you. Thank you so very much.
I agree with Parag.
Thank you so very much for the closing comment. But indeed, this is something I remember the last time I did a show long ago on the collegium system. And one of the panelists, a retired judge, says that India needs this system because every democracy matures separately and India is not ready yet to give up the collegium system. And he says because these are things which are unique to this country. And as we see, we take even to social media differently. No other country sees the trolling of judges the way we see in India. And that is why we are all concerned about it when we took up this issue. And when Justice Chandrachud took this up is something when we were worried, because I think we all acknowledge the fact that he's one of the most open and liberal judges we have, in the sense that he accepts live streaming. He accepts also digital courts. He's been the most, what you can say, endorsed votary of the online hearing system, and we expect a lot during his tenure on that. But I like to thank Mr. Karanjawala, Managing Partner Karanjawala and Company, Senior Advocate Parag Tripathi, Mohit Saraf, Managing Partner of Saraf and Partners, and Senior Advocate Percy Bilaboria for sparing time and joining us on this important issue. Viewers, thank you so much for tuning in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.